Hi, and welcome to The Law Simplified. I'm Bandaranayake. Thanks a lot for joining me for the second live Q&A session that I'm conducting. Last week, if you joined us, we did criminal law, where we went through the theory components. We went through a fast track, so to speak, of a little bit about criminal law, and then we had a very vibrant Q&A session where those who joined us put down their questions on the comment section, and I tried to go through as much as possible within the limited span of time that we had. But before we proceed, let's give it a minute or two so that those who are not here can join us. And I hope everyone is staying safe in this new normal, as I've now come to refer to it as. Nevertheless, our academics and our studies have to proceed and go on. So as I'm proceeding with these Q&A sessions, do let me know on either the comments on this very channel, the community section, or even reach out to me on social media in relation to Facebook, or the links in the description, and let me know what other elements of the law that you'd like to go over. One of the fundamental aspects of studying law is, even though that you can do it in isolation, even though that it's somewhat it's a subject that you can do in solitude, it makes better sense in terms of articulation, in terms of arguments, if you are able to really have a community built up and you're able to have a lot of people around you. So this platform, I'm trying to make it as cohesive as possible, and do bear with me on a week by week basis. I try to get better and better at this in relation to the live streams, but let me know your comments and suggestions as well, so that I can tweak and improve this as we go along. Slowly but steadily, I see that there are several viewers that are joining us, so we'll give it a minute or so and then proceed. Just to give a outline of what we are going to do in these Q&A sessions. One misnomer that I had in the initial Q&A, when we did the criminal law Q&A last week, is that time needs to be spent more on the theory as opposed to the questions. But looking at the questions that came about, I think it's much more helpful, considering the fact that most of y'all are currently in your examination period in the semester, towards the latter end, the tail end of your semester. It makes better sense to alleviate any issues that you might have, rather than going in detail into theory as such. Now, having said that, one of the fundamental ways in which I plan on structuring these Q&A sessions is to have about 1/3 of the 30 to 40 minutes that we have to outline very briefly things that you might not be aware of in relation to thinking about contract law, whatever subject that we are doing, and then push onwards to the Q&As that I've received before this session itself and during the session when you put something down on the comment section. I do see some of the comments and some familiar faces as well. Welcome to the Q&A session for contract law. Okay, since we have a good fair number of concurrent viewers going on, let's begin. First and foremost, in relation to this particular subject, when you think about contract law, by and large, what I always tell students to think of it as is to primarily consider it as creating what I like to refer to as one-on-one relationships. So what that means essentially is that it creates a situation where a court of law won't automatically be part and parcel of it. So if you recall, when we did criminal law last week, the way that I structured it and the way that I explained it was that it creates a one-to-many relationship, where a state or a government stipulates the law or the rules, and it's binding towards every single person out there. You don't have a choice whether you agree or not. You don't have a mechanism of negotiating on it. Rather, the government or the state tells you what the laws are, what the rules are, and you have to follow those rules. Those are your obligations as such. The outcome, once again, is that if you don't follow those rules, you are punished, either by way of imprisonment or a fine or both. Contract law falls into a different regime. We call this as part of being the civil law, which deals with essentially the rights of people. And you can consider contract law and the judiciary at large as it relates to contract law as being like a service provider. In essence, when two parties enter into a contract, it's between them. Only when there is some sort of dispute in place would, for instance, a court of law would have to be invoked by one or more parties. Right. Now, having said that, the fundamental thing that we need to remember when we think about contract law, when we think about the civil law jurisdiction, is the fact that it is by and large a life cycle. What I mean by a life cycle is, unlike many other subjects that you will encounter in your LLB, GDL, or even LLM, this is quite sequential. And on the one hand, it's easier to understand because whether we like it or not, contract law is something that we will encounter on a day-to-day basis. You don't even have to be a legal professional, and without even knowing, you would have encountered situations where contracts have taken place. From as simple a thing as going into a shop and buying a loaf of bread to more complex mergers and acquisitions that you might have been a small cog or a small part of in your corporate or work life, so to speak. Now, having said that, what do I mean by this life cycle? What do I consider as it being something to the effect where one party and another party enter into a contract? So basically, when we think of contract law, you can think of it as being broadly broken into three main stages. You have the formation, you have the operation, and then you have the discharge or the termination of it. This is what I mean by a life cycle. A contract has to be made, it has to be executed, and then it has to be ended. Nothing lasts forever, yeah? So because of that, when we look at this whole subject as a life cycle, it makes it easier for us to position individual topics into these categories. So for example, whichever syllabus that you might be following in, it might be an LLB, it might be a GDL, it might even be an LLM, or even a lower level 3 diploma or certificate program. Whichever one it is, by and large, there are several topics that you would encounter when it comes to contract law. You'll have topics like offer and acceptance, cumulatively considered as agreement. You have consideration and the essential formative requirements like intention to create legal relations. You have terms, which are the obligations, and you have the regulation of those terms, which deal with exclusion clauses that parties might want to put in to negate or mitigate liability. You might have the actual performance, damages, as well as performance and various obligations not being fulfilled, thereby breach, sometimes not at the fault of parties, which amounts to things like frustration, mistake if it is bilateral, and then finally, things which parties might have said outside of the contract that affect the actual functioning or the premise at which one person entered into the contract. We call these as misrepresentations. So from all of those topics that we had just spoken about, you can think of and couple offer and acceptance or agreement, consideration, and formative requirements, intention to create legal relations, into the formation component, the starting of the contract. These are the elements that you need to begin a contract in the first place. Then, when we look at terms and regulation of terms, even performance at that, these amount to the actual operation. This is the heart and soul of it, the actual cog, so to speak, of the clock that needs to work in order for the contract to take place. And then finally, when you have breach, when you have frustration, when you have mistake, and even to a great extent misrepresentation, these relate to the termination components, the things which have taken place that would require, or rather that would mean that the contract can no longer take place, or it won't happen at the quality expected by the parties. Now, generally speaking, if I am to just outline three of the fundamental topics that are pivotal in relation to contract law, I would argue that agreement, which is offer and acceptance, takes center stage, because this is what we like to call the vanguard, or the threshold by which the gateway to contract, essentially. Now, when I call this the gateway to contract, it means when you have a particular offer made by a party, which is a statement on certain terms, which is unambiguous and directed at a particular person, and that is met by an unqualified assent, which is called an acceptance. This is an agreement, which means a cementing of the obligations that the parties are agreeing to enter into. So this vanguard component, when you look at examinations, when you look at the cornerstones of contract law in general, this is what takes center stage. Many students find this, on the one hand, easy to understand because it's the most elemental concepts of contract law, but there is also a misnomer that takes place in terms of agreement, in the sense that students feel agreement equals contract. It is not. Agreement is merely the cementing of the terms by which the parties are thinking of getting into a contract. There is no contract without the next most pivotal element, which you would have come across many a times in your studies, which is, of course, consideration. So consideration, by and large, makes, as Ewan McKendrick considers in his textbook Contract Law, the badge of enforceability. This is what provides for the context of the contract itself. It is consideration which makes a contract a contract. It is the bargain that both parties have. Now, I'll try to simplify this into a concept or into a premise that not only is it understandable, but in a way in which you can think of and associate with your problem-based or essay-based questions as well. You can think of consideration as the loss and a gain accrued to one party and vice versa. Many students equate this to the monetary component, and this is true 9 out of 10 times. But the goal here is to look at consideration in the perspective of what do I get in return. That's the idea here. If there is one party not losing anything while gaining something, the law will stipulate that he owes something back. And the same concept applies the other way around as well. Now, consideration, if we are to go into detail, there's a lot to cover. There are different principles as well. But once you take agreement, which is offer and acceptance, and consideration together, you have now created or formed what we like to consider as a contractual instrument, a contract, which is enforceable against both parties. Both parties can sue and be sued, so to speak. Now, generally speaking, apart from this context, apart from this particular problem, when we look at contract law as a whole, many students tend to omit or not think of the next stage of the contract, because merely having the contract itself is insufficient. You have to deduce what terms or obligations, as I like to consider them, is between the parties. Now, one major concern that often is plagued not just by students but also by professionals who essentially have firms and companies vetting over words that are stipulated in written forms of contracts is how best can you associate certain terms, which are warranties or conditions, as being important and incorporated into contracts. This is why the third most important element in contract law, this is not to say that there are no other topics which are important, but for the purposes of our lesson today and to gap any nuances or missing links in the law that you might have at this stage closer to an examination, the third most fundamental aspect of contract law that we usually go through deals with the operational elements of it, namely that of terms. So terms or obligations are the heart and soul of a contract. The actual establishment of it and then later the regulation of it makes terms one of the pivotal aspects that you need to think about. It might be expressly stated within the contract, or more likely when there are contracts which are much more implicit in nature by virtue of conduct that it is determined. But whichever form it might take, terms has to be deduced by the parties themselves in the beginning, if not by virtue of what has taken place. You have probably already gone through elements such as what amounts to a warranty, what sort of remedies are possible if there's some sort of breach in those warranties, how do you define a condition, and then what amounts to an innominate term. Now, when we take all of this as a whole, when we consider both the formation components and the operational elements, the clear understanding that you should have in terms of contract law is that laissez-faire, freedom of contract. So why I keep on stressing that as well, and why I started this particular live Q&A also by saying that courts of law are invoked as opposed to coming into the picture automatically, is because this falls pivotally into civil law, where the judiciary and a court of law amounts to a service provider. When you think of them as a service provider, this makes it far much more simpler. And always remember that whatever is in writing is primary, but where that is lacking when it comes to terms, the conduct of the parties are also absolutely critical. Because it's the conduct, not the form, but the function, that a court of law will look at in determining how much of an imbalance the parties might have and what type of terms are most important to the functioning of a contract. Okay, so I wouldn't want to take more and more time in going through theory, because contract law in itself is quite interesting, but it is quite a hefty subject in itself. So what I'd like to do is to take this opportunity to open up the chat box. I do see there are quite a number of questions or quite a number of comments that I've gotten. So I need to go through and see what sort of questions are posed to me as well. But do use the comment section from now on, so that then we can go through Q&A and questions as such. But first and foremost, in terms of the Q&A, there have been a few questions that I've gotten in the past few days in relation to the original post in our community section on the Law Simplified. If you haven't seen that, do like and subscribe to the Law Simplified channel. There's a thriving community there of students who comment on each other's questions as well, and it's quite fascinating to see that small community building up as well. So do subscribe to it. There are videos on a weekly basis in terms of theory as well as examination technique that I put on there as well. So there were several questions in relation to this community section that I received. So a common thread though, because most of the questions are on the same principle, and something which is very timely as well at that, is on the notion of frustration and a force majeure clause essentially. Now, generally speaking, there were a few questions, one of which related to the current pandemic situation that we are facing, whether it amounts to frustration or whether it amounts to force majeure. So I'll try to answer those questions in the context and couch it in the context of force majeure and frustration in general first, and then specifically to the conditions that we are facing today. So usually when we look at the termination component of a contract, we are 9 out of 10 times we look at fault. What I mean by fault is a breach by one or more parties. This essentially means that the parties had agreed to deal on certain terms, and those terms have either been completely elapsed or not done whatsoever, or not done to the level or the quality that was required. So it's not of satisfactory quality on the one hand, or not fulfilled at all. Either way, there'll be first an indication that has to be made by court whether the type of breach amounts to a warranty, a condition, or an innominate term, and based on that, a remedy will ensue. So if it's a warranty, it might only be damages. If it's a condition or an innominate term, it'll be termination absolutely, but it might be damages as well based on the circumstance. But in whichever way, the word there is breach, and that amounts to a fault by one or more parties. Someone has done something wrong. When we talk about frustration and force majeure clauses, we are not talking about fault. We are talking about a situation that prevents the contract from either happening at all or at the quality that is essentially required, that prevents it's not essentially by the virtue of the parties themselves, but something outside of the control of either party that makes a contract not being able to be fulfilled at the relevant quality or at all for that matter. So that is the general outline and the gist of frustration. But if we take this current pandemic as whether it amounts to a frustration or whether it amounts to a situation that amounts to frustration, that's quite a tough question to answer, because there are multiple metrics to determine there. One, you have to understand what type of contract it is. Two, you need to determine how foreseeable was this in relation to the contract being entered into in the first place. So for example, let's take a time-sensitive situation. Let's take an ordering of a vehicle, let's say, for an emergency purpose, an ordering of a vehicle from one country to another. And there is a known threat level, let's say, in the world, that there is a likelihood that, as we are seeing today as well, ports, airports all around the world are being closed down and shut down. So if it was likely, it was foreseeable, let's say, that this would happen, that would put into question the ability to frustrate the contract. But presume this was something that was unforeseeable at the time the contract was entered into. It was not seen by either party. And then this immediately takes place, which prevents the contract from happening. Then yes, it might amount to frustration. It might amount to a force majeure clause. This is why in many contracts which are well formed, where not only are the obligations outlined in the contractual document itself, but the nature of those terms are also outlined, where they say these are conditions and these are terms. There'll also be a break clause or a force majeure clause as well, which stipulates if XYZ thing happens, it's no fault of either party and the remedy will be such. So they would plan out for that as well. Right. So I hope that answers one of the community-based questions that kept coming up constantly. Now let's go through the live chat and see what sort of questions are there. Okay, so there's one question, breach, severance versus termination and remedies arising. So once again, this goes into something very similar to what I said earlier, which is you have to first determine the origin or the nature of the situation, why this has taken place. Why is the contract not either able to be performed at the necessary quality or not at all? So when you say either breach or severance, that essentially relates to something that you don't want to happen that is happening. Whereas termination, it might mean either a natural termination, which either at the end of a particular contractual period, or a break clause or something or the other that was foreseen by the parties taking place. Now, when it comes to remedies, it depends on the nature of that. So if it's a breach, it will depend on what type of term it was, whether it's something that allows for damages and termination or just damages alone, or nothing for that matter. It depends on the circumstances. Whereas if it's for termination, depending on that termination being identified in the contract, the remedy will also be outlined in the contract. So you don't have to essentially get a specific remedy given unless the contract is silent on it. So this brings me to a very good point in relation to contract law as well. Once again, a court of law is being invoked because something is defaulting or silent in the contract, because the parties have not accounted for it. So if they haven't accounted for something, that is when the court steps in, much like an umpire, to coin a cricketing euphemism, if I may, just to say who's right, who's not essentially who's right or wrong, who's more right versus who's more wrong. Because you have to always remember that contract law, the standard of proof is on a balance of probability. Moving on. There's a connected question, I believe. My understanding is that non-performance can be discovered at any time. However, defective performance is after consideration is accepted. That is true. That is correct. So again, it goes back to that same principle, right? Because even if we look at, let's say, obligations or terms, those terms are by and large associated with their importance, whether it be express or implied. The premise is to consider how important it is to the functioning of the contract and at which stage can it be determined. So when it comes to quality or the performance quality, that can only be assessed perhaps at the time the breach is taking place. So depending how much it goes to the root of the contract, it might even be considered an innominate term, which may give a remedy of termination as opposed to just damages. One key fact is you need to understand that all of these things is in relation to a case-by-case basis. No two cases are alike, and there are instances that courts might even distinguish from a precedent case primarily because the circumstances call for it. They're very lucid or fluid rather in that context. What next? Okay, so there's an examination question here, or a question related to an examination. How do we handle the overlap of topics in an examination? For example, breach of contract and frustration. So this is Chitra. She's one of my fast track students as well. So thank you for the question, Chitra. So the short answer to that question is that most questions usually don't overlap outside of those categories. So what I mean by that is, if you recall in the very inception, I mentioned that if you take all of the topics in contract law, they can essentially be categorized into being within the context of formation, the actual operation, or termination or the discharge of it. So generally speaking, you will get agreement and consideration questions within one sort of question. Very rare that as well. Most of the questions that I've noticed fall into the agreement category only as opposed to with consideration. Same thing happens with terms and regulation of terms in terms of operation. Same thing with discharge. You might have performance breach and frustration together. So it's not really about the distinction as such. It's really about working within the parameters of that category. This is not to say, and I highly advise against targeting questions. It's always better to have an understanding of the life cycle, as I considered, for contract law from beginning to end. You might have gaps in terms of case law substantiating certain small points, but know the law, know the primary and secondary categories of law. That's what's most important. So to answer your question slightly along the way, when you have a question, let's say on breach and frustration, try to compare and contrast. Try to take that aspect of fault that I mentioned. Everything other than frustration and mistake usually deal with fault. It's because the parties had either agreed to it expressly that they should do something and they don't do it, one or more parties don't do it, or as court will consider, their conduct was such that they ought to have done it, but they didn't. I hope that answers that question, Chitra. Okay, so moving on, there are several other questions here, so I'll try to get through as much as possible within our time frame. Okay. So we have another question. What is the relationship of franchisor and franchisee? If franchisee is the owner of immovable property, where franchisee doing the business like selling products of franchisor. So if I'm understanding your question correctly, Sajjad, just to outline that a bit. First thing is, I think you want to know the distinction between a franchisor and franchisee. That's one. And I think the second thing is where the ownership lies, where the property transfers happened. Okay, so in relation to the first question, the difference between a franchisor and franchisee, the premise here is you have one party that has, let's call it, absolute ownership. And for a specified period of time on certain terms, he will outline a subset of his rights to another party that we call franchisee. So this franchisee has a qualified set of rights of the franchisor. What I mean by qualification is usually it's based on time, and permissions, so to speak. Because you have to remember that contractual obligations relate to permissions. So when you have a franchisor having a number of rights in hand, he might divest certain rights for a period of time, sometimes exclusively and sometimes not, to another party to engage in business for money consideration. So if I'm to put it to an example, these sessions are under the umbrella of the Law Simplified, which is my organization. So the Law Simplified has a number of rights when it comes to the content, from the copyright to the ownership to everything. When it comes to the Law Simplified, from the sessions to the courses to the workshops, the works. Now, if I so choose to do it, I could take a subset of these, franchise it out to someone else for a period of time to do similar sessions in a certain manner, or to play the videos or to play the lessons in a certain manner. Now, that extinguishes at a particular time frame. When that takes place, the rights extinguish and the franchisor gets all of it back as opposed to the franchisee. Since there's a bunch more to go through, I'll try to go through them and then I'll track back Sajad. Excuse me. Okay, so it says explain when an offer ceases to be capable of acceptance. So there's a number of situations. So here, on the one hand, you can think of an offer no longer existing. So when the offer comes to an end, so to speak. On the other, you can look at it in the context of being incapable of acceptance. So let me put it this way. There are a number of ways that an offer can come to an end, including acceptance. So acceptance is one way the offer comes to an end, and then it becomes agreement as a whole. But apart from that, the death, for example, of the original offeror before the acceptance takes place not only ends the offer, but also makes it obviously incapable of being accepted. Revocation ends an original offer. You might have lapse of time that is incorporated into the contract, which means you cannot accept it beyond that period. There might be certain conditions, conditional offers that are made. If unfulfilled, unfortunately, you cannot accept it either. Just to outline this really quickly so that we have a more visual aspect of going through it, you'll notice in terms of the top right there, various methods of ending offer. You can have a condition which is unfulfilled. It can be rejected, change of mind, which is revocation, lapse in terms of the time factor, and usually the death of the offeror. I hope that clarifies that question. Okay, so there's a question from Ajit on how do we use specific performance. So most of the, if not a majority, let's say, of the remedies and the principles of contract law fall within the ambit of common law. So common law or judge-made law relates to black letter and very clinical aspects of the law, which are written down, which are very technical and which are very technical, and to them, for the most part, they are very stringent, very clinical in nature. But later on, if you are going into your level 5 and level 6 courses such as equity and trust, there's another branch of law known as equity. So equity relates to fairness and justice, and for the most part, it's something where judges and a court of law can sidestep common law for the greater good, to provide redress for unfairness that might happen. So injunctions and specific performance would be remedies in relation to equitable principles. So for example, if you take promissory estoppel in consideration, that's an equitable, that's part of the equitable jurisdiction. When you provide a remedy for someone who has a claim under promissory estoppel, so that his consideration, he has been made a representation to, he has relied on it and suffered a detriment, and the other person is refusing to fulfill his promise, a court of law may invoke not damages as such, but specific performance, trying to force the party to do what he promised originally to do. I hope that clarifies it, Ajit. Okay. So I have one one student saying, looking over the thought section, thank you very much for it. You're most welcome. I hope the lessons have been helpful in relation to this platform as well, and whatever other courses that I provide online. Okay, what else? Okay, I think I missed out on one question, so apologies for that. What is the difference between these three sections of Indian Contract Act, section 73, 74, and 75? Miranda, I apologize. This session and pretty much every single one of my lessons online relate to English common law. Primarily speaking, I'm not very familiar with the sections of the Indian legislature and in terms of their Indian Contract Act. Perhaps you can send me a PM and I can look it up and let you know. Okay. Any other questions before we wrap for this particular session? I do hope it was quite helpful. Okay, we have one more question there. Impact of Consumer Protection Act and contract law. So this is actually quite a timely question as well. Thank you, Maria, for that. When it comes to the newer 2015 Consumer Rights Act, it plays a very pivotal role in the overarching scheme of regulation of terms at that. Fundamentally, if you take contract law in the context of the UK common law, you have two very important pieces of legislation that regulates, or that used to regulate primarily, protection of the consumer, of a customer in a B2C relationship. Historically speaking, back in the day, you might have heard of this sentiment as well, called caveat emptor. So originally, century ago almost, the principle was that of buyer beware. But then slowly with the shift in consumer protection, this changed into caveat vendita, which is seller beware, where the seller has to be very clear about what product is being sold and that the customer receives that which he or she had wanted, essentially. Now, having said that, the two specific statutes that I spoke of earlier were the Sale of Goods Act of 1979 and the Unfair Contract Terms Act of 1977. On the one hand, the Sale of Goods Act dealt specifically with sale of goods which are of satisfactory quality and fit for their purpose, and instilling them as conditions of a contract, putting the burden on the seller as opposed to the buyer, which meant that if the buyer is unsatisfied with the goods as well as it wasn't fit for the purpose that he or she intended, that was a breach of a contract, a condition at that. That was the Sale of Goods Act when it comes to B2C or business to consumer transactions. The Unfair Contract Terms Act of 1977 did a similar thing, but in relation to exclusion clauses that sellers would rely on in order to negate, not limit, but to exclude liability in its entirety. So by virtue of Section 9 of the Consumer Rights Act of 2015 and Section 62 and 63, these two acts, these two statutes, Sale of Goods Act as well as the Unfair Contract Terms Act, have now been further bolstered and have now received even further protection in terms of consumer rights. So that's why the CRA 2015 is quite important in terms of civil law and in terms of contract law in the UK today. I hope that is clear as well. Okay, what is contract of service and contract for service? So a contract of service is a good question as well. A contract of service and a contract for service differs in relation to what it ultimately accomplishes. So when you have, let's say, for example, one individual doing something in the course of their business that is service oriented, that would not only come under the Sale of Goods and Services Act, but amount to a contract of service. A contract for service might more often than not be a one-off. So it's something that relates to not a business endeavor as such, but you are being paid consideration for a particular task at that. I hope that's clear. Okay, so there's a bunch coming up. I'm trying to get through as much as possible within our time factor. Can you do judicial review? Judicial review will be part of the public law live Q&A session that I'm hoping to have next week. So when you do see the sign up call out or the enrollment call out, do set a reminder for that. Omosa, in relation to how do you approach questions as regards contract law, that is an entire session onto itself. There are several videos on this very channel, as well as specified masterclass and fast track courses on my online law school platform, which you can have a look through the links in the description that will appear on this video as well. Do check them out. Okay, so I have to end our session for today on that. There's quite a bunch to go through. If you do have more questions that you'd like to outline, as well as reach out to me to perhaps have an ad hoc or a fast track session as well at that, do send me a message through the links in the description. There is a WhatsApp number on that as well, which you can reach out to, drop a message, and then you can get in touch. I hope to continue these series of sessions also, perhaps to have a series for each topic as well, or each subject as well, a bit more detailed. There's only so much that we can do in the time frame that we have, going through every single question. And this platform, I'm quite happy that the community is growing as well. And in this trying time, I hope that you find community in this particular platform, because it's very hard to have conversations being in isolation and then moving apart in this global pandemic state. But having said that, thank you once again for joining me for today's live Q&A session for contract law. Do subscribe to the Law Simplified to get updates on newer videos that will come up on a weekly basis. More of these, as well as workshops and other examination technique videos as well. But until the next time that we meet, have fun, stay safe, and as always, obey the law.